all students. Welcome to iLearn IAS Theory of Prelims mock test discussion for mock test number 21. So in continuation to the last mock test discussion, which was mainly about the political system and the parliament, in this mock test we will be analyzing questions related to local self-government, the constitutional and non-constitutional bodies, Indian judiciary, and executive and other political dynamics. So we have 25 questions here, and so let's start. Okay. Let's look at the first question. Consider the following statements. It's about bodies. Okay. Now, one thing about it's about state election commission, right? So one thing about bodies that we should be very much careful is that with respect to bodies, especially the constitutional bodies, we should always remember certain things about it, such as the removal, the appointment, the powers and functions. Okay, these are certain criteria which we should be always analyzing. Okay, that could be clear when we get into details. Okay, because most of the questions associated would revolve around the appointments and removal as well as the powers. Okay, yeah. Look into this aspect. For example, judiciary. In judiciary, what do we look into? The appointment. We look into the jurisdiction, the removal, salary expenditure, and any other developments associated with them. Okay, and of course the power and jurisdiction also for the judiciary. Same way, for every body we have to analyze all the dimensions. Okay, we have to look into the appointment, who makes the appointment, and who is if is the same person who is appointing is the one who is removing, or is it a higher authority who is removing? If there is a change in that, we should be definitely looking into it. Okay, what about the salary, who is paying it, how independent the body is? All those dimensions have to be definitely looked into. Okay, so let us so I will be, wherever required, I will be going back to the polity slides, polity TOP slides. Okay, so that it helps you to understand things in a very easy manner. All right, so let us look into the question. Consider the following statements. The state election commissioners are removed from office in same manner and grounds as a judge of high court. Okay, so we are discussing about state election commissioners and the removal as that of a similar to that of a judge of high court. Okay. Second is, a regional commissioner cannot be removed from office except on the recommendation of the Chief Election Commissioner of India. Okay, so it is about the Chief Regional Commissioner. So again, you see the question is about the body, that is Election Commission, and the focus is on the removal. Okay, so for every body, if you again make it, you can make a table, okay, and prepare it accordingly. For example, you can always refer to those dimensions, that is about the removal, appointment, powers and functions, and thus look into the whole development. Okay, all right. So for the state election commissioner, his removal, always understand the removal is that of a high court judge. Now, high court judge is removed in the same manner as that of a Supreme Court judge. Okay, so this is a right statement over here. And the second point, that is regional commissioners. See, a chief election commissioner is removed as equivalent to a Supreme Court judge, but other election commissioners and the regional commissioners are removed based on the recommendation of the chief election commissioner. This is a very important point and we should be taking note of. Also, another point you should take note of is the state election commissioner is coming not under the Election Commission of India. It is a separate body. It comes under the 73rd Constitutional Amendment Act. Okay, it is to manage the panchayat elections. So that is a different point that you should be noting. Okay, so I'm very sure that you will be very clear about who is appointing the state election commissioner. If you don't know, you have to go back and check for that. Okay, and who is appointing the regional commissioners. All right. Okay, the answer will be, since the first statement is right and second is right, answer should be C. Okay, so next one, let's move to the second question. Which of the following officers are subject to removal by the governor? See, again the question is on the removal side. Okay, so when the governor removes, which all officers can be removed? So this is a question which has been asked in a reverse way. Okay, rather than asking chairman is removed by the governor, they are asking governor can remove which of the following: Chairman of State Human Rights Commission, Chairman of State Public Service Commission, State Chief Information Commissioner, and Advocate General. Okay, so let us look into the question once again. Okay, which of the following are subjected to removal by governor? So which of the governor can remove? We can, if you find this is tough, because we may not always focus on all these bodies, but certain areas we should definitely be very sure. One thing I believe we can be very sure is about the Advocate General. Now, Advocate General's office, it is the governor who removes it by way of doctrine of pleasure. Okay, so we do have four, and okay, so we have four here, here, and here, B, C, and D. Let's keep it. What about State Public Service Commissioner? We know that State Public Service Commissioner, the chairman, is appointed by governor, but his removal is not done by the governor. Okay, it is by the president. Okay, so it is a higher rank who removes it. Okay, so two definitely is not a part. So you can eliminate two from that. Then I think you should get the answer, right? You eliminate two here, you eliminate two from here, and you eliminate two over here also. So the answer would be box. Okay, so second is box, that is 3 and 4. So State Information Commissioner is removed by the governor. Advocate General is also removed by the governor. All right. What about Chairman of State Human Rights Commission? Now you see that State Human Rights Commission, who is heading those Human Rights Commission? It is the judges. And who can remove a judge? Usually, it's of course the retired judges, but who is authorized to remove a judge? Okay, the president. So that principle is respected in the case of state human rights bodies also, and it is for this reason we can also avoid that particular from the governor's position. Okay, state public service I have already mentioned. Okay, state is appointed by the governor, but removal is done by a higher authority. Okay, so let's move on further. Third question: who among the following holds office during the pleasure of president? Okay, we have three options here: Comptroller and Auditor General of India, one; members of Defense Service, Prime Minister. Okay, we have four options, and Chairman of NHRC. Select the multiple options. Let us look into this. So the key point is about the pleasure of the president. When it comes to the pleasure of the president, what do we understand from this? Okay, pleasure means there is no special criteria laid down, and he can be removed by will. Okay, and will is not exercised completely by discretion. There are conditions laid down. And let us look. CAG. We definitely know that CAG is a very independent office, so pleasure does not apply there. So you can eliminate one from that. Okay, the pleasure does not apply for CAG. There's a criteria laid down for removal of CAG. So eliminate one, you get answer almost limited to 2, B and C. Now B is definitely, B and C both have 2 and 3. Let us just go through what could be 4. Okay, let's see what 4 is. Chairman of NHRC. Now NHRC, who is heading NHRC? Just understand this. Who is heading NHRC? NHRC is headed by a retired judge. Okay. Now, do you think a retired judge can be removed by the will or the discretion of the president? Do you think that is possible? While as a sitting judge, he could not be removed. Okay, by the discretion. There was a clear-cut laid down procedure, because this is an independent and a very powerful office. Okay, so the same applies to a Human Rights Commission. The same judge now is retired, but his position as a judge still remains. Okay, so there's a clear-cut procedure laid down. Okay, the fourth also is likely to be wrong. So what is the answer? Answer has to be C. That is 2 and 3. Now what is 2 and 3? 2 is members of defense service. Members of defense service, because the president is the chief of the defense. All the members work under this pleasure. Okay, though they have the tenure and other things, their removal is subject to the pleasure of the president and subject to other conditions also. Coming to the prime minister, of course, on terms of the collective responsibility, the prime minister can be removed and changed by the president. Okay, again, not in complete discretion, but there are conditions to be satisfied. I think you know about it. All right, so let us come to the next question. That is the fourth question. Which of the following comes under original jurisdiction of Supreme Court? Okay, original jurisdiction. Original jurisdiction means Supreme Court alone has the jurisdiction to deal with these matters. Okay, and we know there was a news with respect to this particular thing, and Article 131 of the Constitution was also in news. There was a scenario where regarding the Citizenship Act, Amendment Act, there was an issue where Kerala government did not approve of the legislation passed, that is the CAA, and for that reason, Kerala government adopted a resolution, and later on we know that there is a case filed under Article 131 of the Constitution in the Supreme Court, okay, regarding this particular legislation. So in this context, I think this question has been asked. Oh, so what is? Let us look into that. Okay, original jurisdiction, a dispute related to the federal disputes. Okay, let us keep that there. A dispute between private individual and the state. Do you think between a private individual means like you and me, and a state, do you think that comes under the original jurisdiction of the Supreme Court? No. Okay, that comes, a private individual can go against the state only through writ, right? And writ is a separate jurisdiction in itself. Okay, so that is not the answer. Two is can be eliminated. And a dispute between a state and a government company. Okay, there is no reference as such to dispute between a state and a government company. Of course, they can go against each other, but not under the original jurisdiction. Original jurisdiction means it is between the governments. Okay, which government? Center and the state. Center on one side and state on one side, with states on other side. Okay, state and state, state versus state. That is also possible. So that is definitely what we are referring to as a dispute related to federal disputes. That is center against the state, or center and state on one side versus states on other side. So answer would be, so the fourth one would be A. Okay. Now next one is which among the following is regarding judiciary? Which among the following is not a feature of judicial activism? Okay, so two things to underline. One is not a feature. Second is judicial activism. I'll take you to the other previous slide where we discussed about judiciary. Okay, I want you to go through this thing where we also already discussed about how to approach judiciary. And I told you in judiciary, we should develop the approach in the conceptual, constitutional, contemporary, and connected areas. Conceptual means you should understand certain basic terms associated with judiciary. And constitutional means should know what is the content in the constitution. Lakshmikant is a good book for that. Contemporary means all the recent developments, which could be constitutional or conceptual. Connected matters means terms associated with judiciary. That includes judicial review, judicial activism. Okay, sorry, that includes this one, Legal Service Authority Act, iLearn IAS. Okay, and such related matters. Lok Adalat, all those things would come under the connected areas. Okay, so coming to the conceptual clarity, I already mentioned that you should be focusing on certain definition of key terms in judiciary and also the objectives of judiciary. Okay, then that would include, see, judicial review, independence of judiciary, judicial activism, judicial overreach. Okay, so these are the areas that we should be very clear about the terms, and that has been asked. Okay, so what is which of the following is not a feature of judicial activism? Okay, first one, a court depriving the power of parliament to amend the basic features. Do you think that is judicial activism? A court is depriving the parliament. In Keshavananda Bharati case, court, what did it do? It went proactively and said that constitution can be amended, provided basic structure cannot be touched upon. So that isn't that activism? Okay, it has limited the power of the parliament. Okay, in amending the constitution. So that is definitely judicial activism. Look at this. Okay, so what is judicial activism? A judiciary becoming proactive, judiciary becoming active, and instead of passing passive judgments, it is getting more active and delivering judgments in which there used to be a lack of activity on the side of the executive or the legislature. Okay, that is activism. Okay, those provisions which were sleeping, which was in the nature of a sleeping article, those have become active, and the powers and the rights started getting expanded. Okay, Article 21's expansion is the best example for judicial activism. The rights got redefined. Okay, the ruling of the court based on, look at the second B option, the ruling of the court based on the personal consideration of the judge rather than the existing laws. Okay, so the ruling reflects some kind of personal considerations, judge's personal consideration, whose personal values are included in it. Do you think that is for activism? Of course, when you become proactive, your ideas, your understanding, okay, your experiences also gets reflected in the judgments. Okay, so that also is part of judicial activism. Implementation of due process, this I have already mentioned, the wide expansion of Article 21, how procedure established by law had been converted into due process of law, and how that has reshaped the reading of Article 21, how Article 21 life got redefined, liberty got redefined. Okay, recent case of right to privacy or the right to access to internet. Okay, all these are actual developments of Article 21. Okay, so that is also a way how the judiciary became active. Court encroaching on legislative and executive jurisdiction. No, no, that is not the real idea behind judicial activism. Why? Because judicial activism means where there is a lack of legislative intervention or where there is lack of executive action, judiciary tries to come there and then call upon the executive and the legislature, okay, to act upon. Okay, the important Vishaka case is a good example of activism. Okay, but it does not encroach into legislative and executive jurisdiction. The moment it encroaches into legislative and executive jurisdiction, it is called as judicial overreach. You're overreaching, you are crossing your limits and getting into the legislative and executive field. Okay, so this is a, so there is a very thin thread that separates activism and uh, overreach. Okay, so activism is within its own playground. Overreach is where you cross your playground and get into the field of other. Okay, so that is the difference. The answer is D. So 5. Coming to the sixth one, consider the following statements regarding official language of the Union. Okay, so official language. Do we have an official language? Yes, we have official language. And what is the official language? Think about it. Okay, how many official languages do we have? Think about it. Okay, let's look at this. Constitution does not lay down. No, Constitution definitely lays down. Constitution lays down about official language. Constitution does not lay down about national language. There is nothing about national language. There is no national language for India. Okay, there is official language. Okay, earlier it was English, which could have been continued for some time, but English is said to be replaced by Hindi. Okay, but due to certain political developments and federal based developments in our country, it was understood that Hindi and English both will be continuing. Okay, and English will not be replaced. That's a current understanding about the official language. Come to the next point. All proceedings of the Supreme Court are to be in English only. Considering the diversity in our country, considering that there is only one Supreme Court where all the state representatives as well as state matters are to be taken up, then the better tool for communication would definitely be English. And that is the basis why all proceedings in the Supreme Court are to be in English only. Okay. So it does not lay down, this is wrong, this is right. Constitution imposes a duty upon the center to promote spread and development of Hindi language. Okay, so do we have it? Is Hindi language being promoted by the center? Yes, there is a duty upon the center. Why? Because again, considering the values of the diversity and considering that there should be a spirit of fraternity and unity among the units in the country, it was decided then that a common language should be promoted from the center to bind this country, okay, in a unified manner. Okay, and that is one of the provisions that is mentioned in the constitution, that center is given that duty. Okay, so 1 is wrong and then 2 and 3 is right. The answer should be A. Okay, so that is our question number 6. Now 7th one, let us come to the 7th one regarding the power of the Supreme Court to punish for contempt. Which among the following statement is correct? Now contempt of court is a power that is given to the judiciary. Okay, so what is the power that we are referring to? The Supreme Court has, let us look into the statements. The Supreme Court has the power to punish for contempt of High Court and tribunals. Okay. Now, when does the higher contempt factor come in? Okay, where is it mentioned for contempt? Contempt, you will find it in Article 19, very important. Article 19, reasonable restrictions. 19.2, there is a reference to contempt of court. Okay, contempt comes in when a provision or the decision of the court has not been abided by, or any activity which tends to harm the image and reputation of the judiciary also can invite contempt. Okay, now contempt has been codified by the parliament. Okay, a law related to contempt has been codified by the parliament by passing the Contempt of Courts Act. Okay, according to which contempt can be criminal in nature. Okay, so that is a criminal contempt also. That can be civil contempt as well, but criminal contempt is also possible. Criminal contempt means the violation of the Supreme Court orders or any harm that is being caused to Supreme Court. Okay, and such kind of damage caused can lead to an imprisonment of the person who is causing it, or anybody who is violating the Supreme Court's orders. Okay, the Supreme Court has power to punish for contempt of High Court and tribunals, which is right. Okay, so that is right. And Parliament can regulate. I told you already. There is a legislation that is about Contempt of Courts Act, according to which the Parliament has defined what contempt means and what punishment means. Okay, so the seventh answer is C. Come to the eighth question. Which among the following is exempted under 73rd Amendment Act? Okay, I already mentioned to you that 73rd Amendment is a very important constitutional uh, amendment which you cannot miss anytime. Okay, and it has been repeated also in the slides, the importance of this particular legislation. Okay, so I want you to know the key important provisions. Where does it apply? Okay, the process related to elections. Okay, and the connected matters, that is Farmers' Rights Act, PESA, Grama Sabha, MG Narega. All of these uh, should be well known. Okay, so this is the areas that you should study with respect to the legislation. I also told you when it comes to amendments that 73rd and 74th amendment. Okay, 73rd and 74th amendment has to be necessarily covered and all its features. Okay, again your textbook is sufficient for that particular purpose. Also NCRTs. Now, which are the following are exempted under the Amendment Act? Okay. Now, what is exempted? Certain northeastern states are exempted. Then scheduled area is exempted. Then tribal areas are exempted. This is what we learn. Okay. So let us see what. Okay, Nagaland. Nagaland is exempted. Correct. Now, scheduled area. I told you scheduled area. Okay, as per the fifth schedule, the fifth schedule areas are exempted because of the high tribal population existing in the region. Okay, so they need their own special laws. Union territories, no, there is no such reference. Union territories are not considered as exempted from this. Okay, and we have tribal areas of Assam. Okay, so yes, again, tribal areas, because of the high tribal population, has been considered that special provisions needs to be provided for them. And so our answer would be in this case 1, 2, and 4. That is B. Okay. Let's come to the next question. In which of the following cases governor is not allowed to exercise his pardoning power? Okay. Now, pardoning power of governor and president both are different. Okay. To a great extent, in the sense that the president's pardoning power is much wider than governors. So you need to make a table and write down what is the common things and what is the difference. The common things being that yes, they do have pardoning power but for the governor, it is with respect to the state based laws in which the person has been convicted, and for the president, it can extend to death. It can extend to the decisions given by the military courts, and it can also extend to the laws made by the based on laws passed under the union list. Okay, so let us look into these matters. So which is not allowed? So please underline this particular term, not allowed. Okay. Governor is not allowed. So if the convicted person is sentenced to death, I told you, in case of death, it is the president who can pardon. Okay. So it is not allowed, which is correct. If the person is convicted by the Supreme Court, If the person is convicted by the Supreme Court, can't he approach the governor? Of course, why not? Okay, so the governor can still be approached just because anybody who has been given death sentence, it is highly possible that he will definitely go to Supreme Court. Okay, if that is not allowed, then nobody will go to governor. So if any person who is accused of who is punished with death with a high imprisonment and convicted, there is possibility that he can go to Supreme Court. Okay. Yes. If the convicted person is convicted under a union law. I told you, if it is a union law, then it is the president who gets the power. Okay. And if the conviction is done by a military tribunal, again, military tribunal matters also is dealt by the president. So what is the answer? 1, 3, and 4. Okay. Uh, yes, this is not included under governor. This is not included under governor. The person is convicted by the Supreme Court. Definitely, what happens is it is a governor also has a power to deal with such kind of uh, pardons. Okay, so answer here would be 1, 3, and 4. Let's move on. With reference to Article 123, which of the following consider the following statements? Okay. First one, the ordinance make and what is 123? Always remember such few articles are very important. When 123 comes up, always let it strike in your mind that it comes. It is with respect to ordinance. Okay. It's a kind of a fancy number, but the same way you can remember it is also a very important article. Okay. What would be ordinance making power of the governor? Okay, just rearrange this number. You will definitely get it. Okay, rearrange 1, 2, 3 into another number. You will find the ordinance making power of the governor. Okay, so that is how you remember. It will be helpful for your mains when you write answers. Okay. Ordinance making power of president is regarded as discretionary power of the president. Do you think the president has vast discretionary powers? First of all, the discretionary power of president is highly narrowed down, and ordinance is one of the important power, which means that he will never exercise discretion in it. President's satisfaction is important, okay, not discretion. President should be satisfied. And what is president's satisfaction? President's satisfaction is the satisfaction of the council of ministers, correct? So in this case, what happens is he does not exercise his discretionary power at all. Okay, so that is about the 10th first statement. Okay, come to the next one. An ordinance cannot be retrospective in nature. Is there any provision under Article 123 where it is said that our ordinance cannot be retrospective in nature? What do we understand by retrospectiveness? Retrospectiveness means a law which has application from a previous date. Okay, like if a law is made today, the developments associated in the last 1 year also can be included under the purview of this particular legislation. That is what we call retrospectiveness. Okay. Now, can't we make a don't we make a law for such kind of past events? Okay. Criminal matters we don't make, we cannot make. But for civil matters or civil or anything else other than criminal, we can definitely say that a law can be applied right from previous years. Okay. So if a law can be made, definitely ordinance can also be made. Okay. So this is a wrong statement. So second is a wrong statement. Okay. What about the third one? An ordinance cannot be issued to amend the constitution. That is true. Constitution, the condition is to amend the constitution, a bill has to be introduced in the parliament itself. Okay, and an ordinance is not the way out. Okay, so this is correct. Cannot be. This is wrong. And making power is regarded as this is wrong. So answer should be 3. Let us see whether the answer is 3. Answer should be A. Okay. Yes. Now come to the 11th question. 11th, let us see what the question is. Governor of a state can act in his discretion. Now it is about the discretionary power of the governor. Okay. In what situation he can exercise discretion. Now this is also mentioned in your textbooks. I want you to know it. Make a table or write down in your textbook. Try to reread it. Okay. Think about it. Let us look at it. Okay. It's an easy question. Submitting report under 356. Now, what is 356? Again, this is a very important article. That is why it has been mentioned as article itself. Okay, 356 deals with president's rule. Okay, so governor can submit the report under 356, that is a report to the president that the constitutional machinery in the state has failed. So he gives it, and that is how that is exercised by him by under complete discretion. Okay, reservation of a bill for the consideration of president. If he wants to give something to the president from related to the bill for his consideration, then that is completely a choice of the governor. The governor will never consult the council and say that, okay, now should I give it to the president? No, he gives it by himself on his own decision making. On deciding the questions related to exercise of governor's discretion, very important. Okay, whether a matter comes under governor's discretion or not, it is the governor who decides about it. Okay, appointment of chief minister of a state when no party is in majority. Again, that is the case when there is no party in majority, then governor has to take a call, right? He cannot, the CM cannot advise. So I believe that the answer is well clear. 1, 2, 3, and of course 4. The answer should be dog. Okay. All right. Let's move on to 12th. In the 12th, consider the following statement about All India Service. All India Service was in news. All India Judicial Service was in news. Okay. See, when I say Indian news, All India Service is always in news because of IAS and IPS. But that does not mean that a question can come. What I'm meaning is that All India Service related constitutional provisions, if it has been in news, then you have to definitely take note of it. All right. So let's look into it. Approval of Lok Sabha is not required to create an All India Service. How is an All India Service created? Where does a procedure begin from? It begins from Rajya Sabha, right? It begins from Rajya Sabha. But to create an All India Service, we need a legislation. And legislation, where does it pass? It has to pass from Lok Sabha and Rajya Sabha, both the houses, right? So All India Service can be created only when legislation is passed, and that requires Lok Sabha. Okay, but to bring out that idea, the resolution has to be passed, and that should come from Rajya Sabha. That is a minute difference over there. Members of All India Service are removed by the president. Very true. All India Service is working under the pleasure of the president. Doctrine of pleasure applies, and president is the one who can remove them. Okay. So our first statement is wrong. Second is right, and let's see the third one. All India Judicial Service should not include any post inferior to that of the High Court judge. No, inferior to that of a district court. This is a key point. Inferior to that of a district court. Okay, so this is a wrong statement. So we have 1 and 3 as wrong. Answer should be 2, box. Okay, answer is box. All India Judicial Service was in news. I want you to learn about it. I think I have mentioned it in the slides also about All India Service and the importance of this particular topic. Okay. Let me see if that is there. Yeah, I already mentioned about it. See, there is a All India Service should be prepared. This was in news, and probably that may be the reason why they have asked this particular question. Moving on, in the context of Indian political system, delegated legislation. What is delegated legislation? Delegated legislation means we are delegating the functions. Okay, so functions is being delegated from one authority to other. Now, who is authority? Who will delegate it? Lawmaking. Okay, legislation. Who primarily does legislation? The parliament or the state legislature. When they are delegating, whom will they delegate it to? They will delegate it to sometimes the government. That is where some legislations have rule-making powers for the government. Okay, let us take the corona issue. In corona times, the legislation which was involved was National Disaster Management Authority Act. Okay, NDMA was the legislation which was in action when this whole pandemic was spreading. Under that, now that was a legislation. Now, under that, guidelines were issued by whom? Did the parliament issue the guidelines in this COVID time? No. The guidelines were issued by the government. Why did the government do that? Because government got the power from the legislation made by the parliament. This is what we call delegated legislation. So the central government got power from the parliamentary legislation, because parliamentary legislation gave them the power to make laws. And that is what the first point is. Delegation of law-making power to the executive. Okay, that is delegated legislation, no doubt. Okay, delegation of law-making power from parliament to local bodies. Of course, why can't? Why can't the local bodies also make laws? Okay, parliament can say that, see, this is matter which is dealing with the local bodies, so it is better that the local bodies deal with it. Parliament, being at the top level, cannot manage all the minute elements, right? So power is given to local bodies. Delegation of power, lawmaking power to judiciary. Now, this is a wrong statement. Why is this wrong? Because judiciary is itself an independent body. You cannot give lawmaking power because judiciary does not make laws. Okay, judiciary is bound to interpret laws. Okay, so in that sense, and judiciary being completely different in India, executive and the legislative both are interconnected, but judiciary always have remained independent and separate from all these things, and therefore this cannot come under check. Okay, so the answer here would be 1 and 2. So that is B. 13 should be box. Okay. Now 14th, with reference to the law commission, so we are coming back to the constitutional bodies. I'm sorry, the non-constitutional bodies. Which of the following is correct? It is neither a constitutional body nor a statutory body. Is it a constitutional body? Do we find any reference about law commission in a statute, in a constitution? No. Is it mentioned in any statute? Is it out of a statute that comes? No. Okay. So it is an extra statutory and non-constitutional body. Okay. It is coming by way of executive legislation, executive resolution. Attorney General is ex officio chairman. Now, this is a misleading statement. Do you think Attorney General is a chairman of this particular body? No, it is often a particular judge, a retired judge of the Supreme Court is often considered to be heading the law commission. Okay, and person in office who is already engaged with multiple facts, he will never be chairing it. So first is right, second is wrong. Commission does not recommend on the matters enlisted in the state list. Why? Why can't the law commission recommend on the state list? What is stopping the law commission? There is a lot of things that the commission has been recommending. Okay, it is irrespective of central list and state. It is bothered about the need for changes in laws. Definitely, it can include. Okay, so what is the right answer? 14th answer should be A. That is 1. 1 is right. The 2 is wrong and 3 is wrong. Okay, this is 14. Come to 15th question. With reference to writ jurisdiction of High Court under Article 226, which of the following is correct? Parliament cannot curtail the writ jurisdiction of High Court. We must be very clear that jurisdiction of the courts cannot be curtailed. We can expand it, but curtailment is you are cutting it short. That is not possible. So Parliament cannot curtail, which is right. High Court can issue a writ under 226 to another High Court. Do you think that is possible? A High Court issue. What is the jurisdiction of a High Court territory-wise? Territory-wise, it can exercise jurisdiction within the limits to which the High Court's jurisdiction extends. Okay, if it is say our UP High Court, it extends to the territory of UP. If it is the case of say our Kerala High Court, it extends to the state of Kerala as well as Lakshadweep. Okay, it cannot go beyond it. So wherever the jurisdiction applies, it can issue orders, but not beyond that. So another High Court will come in another jurisdiction, so this will not apply. Okay, and let us see what is the answer. Okay, so the answer is A. That is 1 only. Second is a wrong statement. Come to 16th question. The necessity of elections in Indian political system pertains to. Okay, what is the question? Why do we have elections? Okay, why do we have elections? India is a democratic country. In democratic country, what is the purpose of elections? Why do we need them? Okay, because we need them for the simple fact that India is being such a large country and democracy, people cannot directly stand or make laws. So they need to represent somebody from their side, okay, who is called as an MP or an MLA. And that is why we call ourselves as a representative form of democracy. For that reason, this is the right thing. Okay. What about the other options? Presence of local self-governing institutions. No, the system of direct democracy not applicable in Indian political context. The constitution as supreme law of the land. That is not the reason why we have elections. Okay. Misleading statements, misleading points. Real answer is representative form of democracy. Coming to the 17th, in the context of Indian constitution, Grama Sabha would be, okay, what is, already, also I have mentioned in local bodies that you should be studying about Grama Sabha, which is again a very crucial area which you cannot miss at any time. Okay, I already mentioned about it here. Let's look into the question. Grama Sabha, who comprises Grama Sabha? Grama Sabha is comprised of all the adult members who are registered as voters. I think you must have studied about it when you studied local bodies. Okay, now let us look into it. All adult, everywhere we have adult. Okay, let us forget about it. In the all adult in the panchayat, it's too broad. No, all adult who are permanent residents. Permanent residence is not a right criteria. Now we have to define what permanent residence is. All adult members registered as voters. Now, voter is a good criteria to do. Okay, so it is like choosing the best among this. Even from A, B, C, you can choose the right one. Okay, okay. So that way also you can come to an answer. But look at this. Okay, registered as voter is a very important point. Okay, they should be an elector. Okay, they should have their name in the voters list. Then they become a member of the Gram Sabha. 18th question. Which among the following are included in the 11th schedule of Indian Constitution? Again, if we look into our discussion, I have mentioned about the importance of studying the provisions associated with this particular area. Okay, it is the local bodies. Secondly, in amendments, I have mentioned that we should be looking into the 73rd and 74th amendment, under which 11th and 12th schedule was added. Okay, all the schedules assume a lot of importance, not only in that area, uh, under the structure also. When we discussed about structure under the parts and schedules and amendments, I wanted you to learn about all the important amendments and also the schedules. Okay, so please go through the schedules. There are a lot of questions previously asked about the schedules, and I want you to please focus on these. What is the question now? Which of the following is included in the 11th schedule to the Constitution? PDS. Do you think 11th schedule also deals with local bodies, that is panchayat related? In which areas the panchayat can make laws? 12th schedule is about in areas where urban bodies can make laws, that is municipalities. PDS. Do you think PDS comes as relevant here? PDS, is it a part of the local panchayat system? Can panchayat make? Yes, of course. Correct. Yeah. What about slaughterhouses? Okay, where do you find slaughterhouses? Do you find it more in rural areas or in the urban areas? We find it in the urban areas where there is a need for slaughterhouses, right? Because there is no way for them to, because there is a lack of land for the allied sector and for agriculture. Okay, so we need a separate place, and that is why there is slaughterhouses and tanneries and industry. Okay, and regulation is required in such cases, and that can be done by the urban body. So 73rd or 11th schedule does not apply to point number 2. If you eliminate point number 2, I think you get the answer. So answer should be B. Answer is B. This is the answer. Okay. Non-conventional energy sources. There is a lot of non-conventional energy sources. Solar energy can be considered as one. Okay, which is also there in a lot of rural areas. Watershed development, very important for agriculture and irrigation facilities, and can be used definitely used in the rural areas. Try to eliminate the options and also come to a conclusion. Okay. Now this is an allied sector, allied area, connected area to the judiciary with reference to Lok Adalats in India. Please look into the question. Lok Adalats is a system constituted under National Legal Service Authority Act. What do you think about it? Okay, yes, this legislation is important. You don't have to go detailed about it, but anything in news, please try to follow about a Lok Adalat. Every Lok Adalat is deemed to be a civil court. Now, it is what is the purpose of Lok Adalat? To give faster justice. To give faster justice, you need to act like court itself. Okay, otherwise it cannot be considered as an delivering justice. So here the answer goes to be 2 is also right. Lok Adalat accepts the cases pending in regular court. I told you, Lok Adalat, the one purpose is faster justice and also faster justice. So whatever is happening in other courts, they can take up those matter into the system and then also give orders. Okay, and those orders can be considered as final. So this is also right. Answer could be 1, 2, and 3. Okay, so that is 20th question, 19th question. Come to 20th question. Which among the following is a quasi-judicial body? Now, what is a quasi-judicial body? This is the key word. Quasi-judicial body is the one which can decide questions of law and question of fact. Okay, but it is not purely a decision making or a dispute settlement body, not a pure dispute settlement body, or its primary function is not just about settlement, but it is about more about something else. It could be executive functions also. Okay, but it also involves a decision making component in it, where the question is about law. Okay, or a question is about fact, and they can come to a conclusion in that. Now, this being the body. Niti Ayog. What is Niti Ayog? The Niti Ayog's website says that it is a think tank. Okay, a think tank would mean that they are working in the research area. So eliminate one. Okay, eliminate one goes. Now still we are left with 2 more options. Information Commission. What is the purpose of Information Commission? Information Commission uh, comes under the RTI Act, and one of the primary function is to settle the disputes with respect to the RTI legislation. Okay, it acts as an appellate body and it decides. So when it comes to decision, it has to take into consideration the law, that is the RTI Act. It has to decide on the facts based on the evidence. For that reason, 2 is a quasi-judicial body. So if 2 is a quasi-judicial body, we have this particular thing, 2, and this particular thing also, 3. CBI. Now, is CBI a quasi-judicial body? What do you think about it? CBI performs the primary function of investigation. It has never given any judgment. It has never given any order. There are CBI court. Don't confuse the CBI with CBI court. CBI court will definitely give orders. Okay, but CBI is an investigating authority. Its purpose is to investigate and inquire into a crime or a matter which is given for its investigation. Okay, and that is being taken to the court, and court will give a decision. CBI for that reason cannot be considered to be an quasi-judicial body. It does this responsibility of delivering, of making inquiry and investigation. Answer here should be box. 20 should be B. Okay. 21. Which among the following criteria are adopted for specification of a community as a scheduled tribe? This is a factual question. You have to know this. Okay, I believe all the things are right over here. Distinctive culture, primitive traits, and geographical isolation, shyness. I'm going for it. It's a factual question, and all the above is the right answer. 21 should be dog. 22. Which of the following appoints Special Officer for Linguistic Minor (SOLM)? Now, where do you find this? This is not much always. This is not considered much important in our preparation time. But you know that this is a constitutional body, and you see all the constitutional bodies, central constitutional bodies. The president has made the appointments there, right? So this being a constitutional body, you can definitely conclude easily that president has made, and since it's a centrally made body, president definitely is the one. 22 should be A. Yeah. Next is 23. In the context of Indian constitution, the term office of profit, it's a very important question. Office of profit always in controversy. There is a lot of debates going around it. Okay, let's see the answer. Appointments made by union or state cabinet. No, there are a lot of appointments being made by union. That does not mean that it becomes an office of profit. A post under the central or state government which yields salaries and other benefits. That is possible. Okay, when there is benefits and salary coming up, and a post has been created as a result of this, and which gives salaries, then there's a possibility that it could be office of profit. Let us look into other options. Appointments made by parliament. Parliament appointments cannot be considered as office of profit. No. Okay, parliamentarians are given office of profit by creating post. Okay, or by giving them post. A post under union or state legislature whose salaries are, again the point is state legislature, which is not right. Okay, so again here we have to cancel this option, we can cancel this option. So the answer could be box, a post under the state or the central government which yields salary and other benefits. Now what is the difference between A and B? A and B, see, in A it's appointments made by union or state cabinet. Now appointments made by union or state cabinet, first of all, there is no reference about the salary and other things. But in Office of Profit, the judiciary has very clearly said that the office should derive benefit of salary or allowances or any kind of benefit. Only then it can become an office of profit. Without any remuneration or any such things, it cannot be considered as a office of profit, because there can be an office, but there is no salary. So that is not an office of profit. Okay. So for that reason, it is box. 23 is box. 24, cooperative societies is an amendment to the constitution. Since this question has come here, I think you should pay attention to cooperative societies. Cooperative societies are statutory bodies. Do you think they are statutory bodies? What is a statutory body? That a statute is creating all the such bodies. There are a lot of cooperative societies in our country, right? It could be whatever we see around the cooperative banks, it could be cooperative banks, or it could be any society that is under Societies Registration Act. Okay. So just because a society is registered under under an act does not make it a statutory body. Okay, cooperative society should, if there is a cooperative societies act, and if this act specifically creates, that legislation specifically creates a society, then that is a statutory one. Otherwise, it is not statutory. All right. So that is definitely not the answer. No, this is a wrong statement. Right to form cooperative society is not a fundamental right. Is it so? Is it not a fundamental right? There was an amendment to Article 19 few years back. Just look into that. Okay, this is mentioned in your textbook. It's mentioned in Article 19 also. Please look into that. It is a fundamental right. Next one is promotion of cooperative societies are enumerated in DPSP. What do you think about it? Are they mentioned in DPSP? Is it likely to be mentioned in DPSP? Yes, it is likely to mention. So this is wrong. This first one is wrong. That is, cooperative societies are statutory bodies. No. Right to form cooperative is not a fundamental right. This is also wrong. Answer should be third. That is, promotion of cooperatives are mentioned in the DPSP. Again, a result of the amendment that was made to the constitution. Answer should be dog. Coming to the last point, that is 25th. With respect to Attorney General of India, consider the following statements. He should be qualified to be appointed as a judge of High Court. No, he should be qualified to be appointed as a judge of Supreme Court. Okay, so first one is wrong. He is not considered as a government servant and is not debarred from private practice. Yes, he is not considered as a government servant, which is correct. He is also not barred from private practice, which is again correct. Okay, but you can imagine whether an attorney general will get time to work for the zone in private practice. He does not usually get time, being a busy authority under this particular constitution. but he is always free to practice. Why he is free to practice? Because he was having his job as a private advocate. After this term, he will have to go back to his private practice, so he cannot be barred from that. Okay, that is why he can continue there the private practice. Answer should be box for 25th. So with that, I think we can come to a conclusion on this whole topic associated with polity. So we have done 2 mocks, around 50 questions were analyzed completely based on the discussions that we had previously, and also based on the important areas that you should be referring to. Please try and attempt all the previous year questions. Also look into the options in the options and the statements. Sometimes options and statement also can become a question in the coming years. So try to follow them. Try to see where focus has been of UPSC. UPSC has been very selective in its paper, especially the polity side. Okay, it has a lot of areas where it keeps on asking again and again. So I want you to pay attention to all these areas where UPSC has been focusing largely, and that especially is the fundamental rights, duties, DPSP, and the preamble, union government, state government, the president, council of ministers, chief minister, parliament, legislature, legislative council, judiciary, local body. These are the areas where there is a high probability of questions coming in. So never miss those areas from the chapters in Lakshmikant. Okay, you can go through my audio in video in this TOP session also, which will help you a lot. And yeah, that's it about polity. I wish you good luck and stay safe, all of you. Thank you.